Yes, welcome to the No State Project. I'm your host, Marc Stevens, author of Government Indicted, a website, of course, marcstevens.net. Glad to be with you here for this December 2nd, 2017 edition of the No State Project, live from the fortified compound in Mesa, Arizona. And thanks for all the support of the show. I do have to say, again, this show brought to you by Chris, Dan, and Bill in New Hampshire, and also Eyal, No State Project Israel, and Nelson. I do appreciate the support of the show, everybody. Thank you very much. A lot of stuff to get to. It's actually getting pretty entertaining. I guess entertaining in a way of like when you are going down the street and there's an accident and you kind of have to see what's happening. You know, so much has been going on. Holy crap. Every day it seems another politician or celebrity is having their careers finally destroyed because of grossly inappropriate behavior. It's, wow. Wow. Hopefully there's not going to be people jumping on the bandwagon just making false statements like, you know, false claims, which, you know, one of the more famous ones, of course, the Duke LaCrosse incident a number of years ago. And they just had recently, but they just found out somebody was trying to scam the Washington Post, and oh man, yeah. So, oh, and before I get into, because we've got 3 pieces of good news, and yes, I will be doing separate videos for this, but it's been a big week for dismissals. Anyway, on to the big picture here. Because what we do here on the No State Project, it's about anarchy. 3 hours of anarchy radio, getting to a voluntary society, meaning that there isn't there's no ruling class. There isn't a criminal organization called government that are forcing us to pay them and have a monopoly over services. The purpose of the show is to also help people to educate and give them the tools necessary to defend themselves. Even if you're not against a bureaucrat, even if it's just a matter of someone is a statist and believes that there has to be government, or is a nationalist for some reason and thinks it's great to embrace nationalism in order to get to a voluntary society, if you want to be able to argue better, and argue in the logical sense, not in the, you know, where it's contention, where someone's just disagreeing with you for the sake of disagreeing and being a douche, but it's to actually have an intellectual conversation, and then we give those, that's what we do here. And these are tools that we use in court. We don't accept sacred cows. No argument is off limits. If someone is making a claim, then they have to put up, or, you know, okay, that which can be asserted without evidence can be dismissed without evidence or argument. So that's what we do. So we had three cases here, and only one of them was traffic. So Eric's been on the show. This is the Massachusetts, one of the cases he has in Massachusetts. And the plaintiff didn't show up, and it was tossed out. Now, this is after he'd been fighting, defending himself pretty vigorously with the motions to dismiss and the discovery request and whatnot. And so he went into court yesterday in Concord, and plaintiff didn't show up. No, it's not a police officer. It's a private party. Didn't show up, and so he was able to prevail and get that tossed down, which is great. We're up against the break, so what I'm going to do is I will give the other 2 success stories when we get back in just a moment, so don't go away. Yes, welcome back to the No State Project here on the Liberty Radio Network, LRN.FM, live from the fortified compound in Mesa, Arizona. It's December 2nd, 2017, and I'm going to get to the calls in just a second. I wanted to be able to discuss, because this is what happens. If I don't say it now, we'll probably get so many calls. Well, we'll see what happens. Then I don't get to do it, but I will be doing a full, you know, a video with these success stories, and post the documentary proof on the website. I don't have documentary proof for Eric's in Massachusetts yet, but when we get that, I will post it. Ryan in Texas had a traffic ticket, and the prosecution, instead of presenting evidence or trying to overcome the motion, withdrew. So big congratulations to Ryan for standing up to these predators in Texas and holding the prosecution to their burden of proof. So Yeah, can we say that it was definitely because of the motion to dismiss? Well, it was more just with the fact that Ryan decided just to defend himself, that he could have put up any defense and the prosecutor would have said, nah, I'm not going to do it. Yeah, that's possible. I don't think it's the most probable explanation here. I think it's because he did launch a solid defense and basically called out the prosecution on their lack of evidence, because if they had the evidence, they would have just provided it and they would have opposed the motion. It's not a lot of time. They just have a paralegal do a copy and paste motion. It's not a lot of work. I mean, for heaven's sakes, they usually just say frivolous at the top. They do this autistic screaming, frivolous, frivolous, frivolous. So it's not a lot of work. The judges usually back them up. But here they did withdraw, because if they had the proof, they would have just provided. So they withdrew. So big congratulations to Ryan. I mentioned this on the Wednesday broadcast. Brady in California, in Fullerton, he stood up to the predators. He filed a motion, the demur, which is the same thing as the motion to dismiss, pointing out that the prosecution had presented insufficient evidence, no evidence to support their claim that the code applied and that Brady had violated it. He also filed a motion for judicial notice so that the judge would take notice of the fact that they have to have this evidence, that it is a adversarial proceeding, and that to have a true adversary requires, pulver's omen, requires an actual antagonistic assertion of rights. But with that, not only do you have to assert that your rights were violated, or a legal right was violated, but you have to have some facts to support the claim. You can look at 1004 of the California criminal code. They have to have that. They didn't. He also filed a Brady request and discovery request. And when he showed up on the day of trial, which was interesting because they actually put him down as in propria persona, not pro se, which is an interesting distinction that they typically don't make. But the police officer did not show up. Yes, people could turn around. First of all, the big congratulations to Brady for not just paying it, but standing up on principle and holding the prosecution to their burden of proof, because the accuser bears the burden of proof. And you can say all day, it's not required, the prosecution doesn't have to prove their claim. And you're just saying it's unfair. You're making the anarchist case for us that it's grossly unfair. And if it's not fair, that would invalidate any decision. So, it could be the police officer just decided to blow off a court date because he just didn't give a damn. Sure, it's entirely possible. Just as it is even more possible that the reason he didn't show up was because Brady launched a very effective defense. So, yes, there'll be critics that say, well, the cop didn't show. But if you go to markstevens.net, you're going to see that we've got an awful lot of dismissals. And yes, some of them are because the cop didn't show up. You stand a pretty good chance of getting the cop not to show up if you present an effective defense. If you call them out on their lack of evidence, you stand a very good chance of the cop not going to court and getting it tossed out. So if somebody could turn around and say, if you had a lawyer in that hat, well, you paid $5,000 and the cop the cop didn't show up. Had nothing to do with the fact that you had a good lawyer. The lawyer had nothing to do with it. It's impossible for us, unless we speak to the cop, to find out what motivated them not to show up. And in California, it's a failure to appear. It's actually a crime. So, yeah. Big congratulations to Eric, Ryan, and Brady for standing up to their accusers and getting these things tossed out. And I really appreciate Ryan and Brady sending me the documentary proof, which I will get up at markstevens.net, hopefully by Monday. So look for that. He's been on the show before from his living room. We're talking with Carrie. Welcome back to the No Stay Project.
Hello, Mark.
Yes, you're back on the show. What do you got for us today?
I'm in Albuquerque right now. I called you last week from my living room, but I'm standing here on the street corner But after the show, I looked at the markstevens.net and I ordered the $25 paperwork that you had for the motion, and I believe I did that Monday, and I hadn't received it, and I'm just wondering how I can receive this documentation because I'm certainly in due need of it.
Well, I'm pretty certain. I usually email that stuff right away with the instructions. So for anyone listening, if you've ordered, unless it was on a Sunday, if you've ordered the motion to dismiss and you don't get it right away, you need to email me. And if I don't respond to an email, then call my phone. Call me. So I do apologize for that. You're going to have to get me off air and let me know what email it was supposed to, because. Did you use PayPal or did you use Cells?
Yes, it went through PayPal, Mark.
Well,
and again, the name on that account was Carrie Bennett.
Okay.
I realize that, but my urgency of getting this documentation is so great. My daughter's sitting in jail. I've got 2 different court cases on myself, and I can't seem to be able to back these people up. Like my last court case, they just plowed through. When nobody showed up, the judge moved it forward, and there was no prosecutor there, but yet the judge moved it forward like 2 different times. So I've really got to get under the realm of reality and start asking a few questions that we can certainly stop these people.
Well, I understand, and the fact that there's about 4 attachments, 5 if it's California. A lot of times, my email will go to someone's spam folder, so I don't know whether they've got it or not. So we're up against a break. So you hold tight. I'm gonna go and I'm gonna do it right now, and I'm gonna check to see what happened and make sure that you've got that. So just hold tight. My name is Marc Stevens. You're listening to the No State Project right here on the Liberty Radio Network. We will be back with your calls in just a few moments, so don't go anywhere. Welcome back. You're listening to the No State Project here on the Liberty Radio Network. I want to bring back Harry calling from Albuquerque now. I've checked, and the last show we did was on the 25th, so if you did it last Saturday, I have no record of it, but it's not something we really need to discuss on the show. What you can do for today is email me. But what else can we talk about and discuss as far as helping you out of this situation? I mean, do you want to say why your daughter is in jail and how long she's been in?
Well, she's been in jail now for about a week or so, and she was picked up on a warrant because failure to appear. But when she had just gotten out of jail, the court date was on the day that she was supposed to get out of jail, and they just basically. The reason why she's in jail is that I believe in Marc Stevens and they don't believe in us, and they just want to punish me, and they've been punishing me now for about 10 years. And I really got to get on top of this thing. I had a house within the city limits of Albuquerque. Zoning wrote me some 200 deals, and I literally had to take my family, and I bought a house out in the county, and and by the grace of God, I earned enough money that I could afford it, or at least I'm making payments. But I've got to get on top of this. But
Carrie, let's deal with what we need to do to help your daughter right now. And I think that either a habeas corpus may be in order.
Yes, sir. Is that like another deal that I can purchase from you, or how would I best get this done?
Well, contact me off air by email. I'll make sure you get the other documents, and I have a template.
Can I have an email?
It's markstevens@mail.com.
Okay.
And we'll square away the other situation.
Gmail or just mail?
Just mail.
Mark, I apologize. I'm out in the field right now. I'm at a major intersection in Albuquerque. Like I mentioned last time, I work on signs. I own a sign business. And, basically I have to look at zoning as a third-party intervener into my life and have to start questioning as to what rights or privileges that should be granted onto them. And one of the things about the greatest part about you is that whenever you just start asking a few simple questions, their little house of cards falls down and they seem to go away. But it's really the process of being able to do that effectively and efficiently. And I really appreciate, years ago, like I was telling you, where I had all these questions that you could ask, and even then that worked. But the times are changing, and they're just more and more money hungry. Well,
they all seem to be, but let's. And the thing you have to realize is that makes it effective is that you have to keep the person you're questioning on point. And so regarding the habeas corpus, yes, that is something that I have a template that I'm happy to send. I don't charge for that. You do have to do some minor edits, of course. You have to cross it over, and so a lot of the language or the text from the motion to dismiss we put in there, but you're showing that and where is she in jail right now anyway? Is it in New Mexico?
Yeah, she's in the Bernalillo County Detention lockup.
Okay, so you'd be showing that the ones who made these accusations and the ones that are holding her, which would be the sheriff, have no evidence. They cannot show that it's legal or valid, because they can't show any evidence to prove that they have any jurisdiction. Of course, their jurisdiction is based on if she's physically in New Mexico, their rules apply. That's just a baseless claim, and without evidence, that would violate their sacred code. And yes, I do have to address this. People keep writing, why do you quote their laws if you don't think that they apply? I'm just showing contradiction. I'm showing how dishonest they are. And that's how you do that. So, yes, I will quote their due process clause to show how dishonest they are. So, please, people, to understand how logic works, how the Socratic method, where you're bringing out these contradictions. And so it doesn't mean, and I even preface it too, Kerry, whenever I may quote the due process clause, but I'm not saying it applies to anybody. We're just showing the contradiction to show how dishonest and criminal these people are. So that would be the basis of the habeas corpus, and that they don't have any evidence to support their claims that they have jurisdiction to hold her.
I certainly believe in as to what you're saying. I'm 57 years old. I have never called a radio talk show other than last week and this week of talking to you. And if there's one person in this world that I truly believe in, is you. And I apologize of my inexperience and ineffectiveness of dealing with them thus far, but I'm up to my neck. My daughter's in jail. The last time they had her in jail, they put her out there in a mental thing to evaluate her. And it's just been my ineffectiveness to protect my family.
It may not be just that. It may just be that these people are overbearing criminals and authoritarians, and they don't give a damn. And we run up against them, the real hardcore ones, all too often. Again, the big Dick Noble up in Massachusetts. In Michigan, putting people in jail just for asking a question, daring to challenge the prosecution's claim. So it's not always because we've been ineffective. You could be as good as Jerry Spence and go in. The judge doesn't have to give a damn about what you're saying. If they've got their mind made up, it doesn't matter. They're not going to be swayed. They have, even if they're wrong and shown to be wrong by a higher court, they don't have to care because they have immunity. It's not like they're going to lose their job because of a bad ruling.
Right.
I think I had something in a last video where they talk about that.
Everything that they do is a misdemeanor, Everything they do is a misdemeanor.
Well, that's not true. A lot of what they do are actually felonies.
Well, I've been looking at it, and I wish I could find the felonies that I could write in there, but I hadn't seen it as of yet.
False. At the federal level, Section 1001 of Title 18, it's a felony to make a false statement within the jurisdiction of the government. So when the Internal Revenue Service makes a false statement and sends it through the mail, that is a felony. When they tell you that taking the position based on your phone calls and admissions from the agents themselves that there's no evidence to support their claim. When they say that is a frivolous argument or frivolous position, that is a false statement, and that is a felony. They should be in prison. If they're worried, these private prisons, if they're worried that they don't have full capacity, maybe they should be pushing these U.S. attorneys to do their friggin' job and put these scumbag IRS agents and DEA agents and fill the prisons with them. Anyway,
well,
they are felonies. Oh, man. Talk about who belongs in prison. Yeah. Let's start with the entire Internal Revenue Service. Yeah, except for maybe the janitors. Put the whole lot of their in prison where they belong. We'll be back on the No Stay Project in just a moment, so don't go away. Welcome back to the No Stay Project here on LRN.FM. Yes, of course, the Liberty Radio Network. And I am Marc Stevens. My website, marcstevens.net. And if you've got an issue with a bureaucrat, a ticket, a complaint from the IRS, something like that, you want to learn how to effectively defend yourself, then you came to the right place. 4 hours of Anarchy Radio every week where we discuss getting to a voluntary society, and one way to do that is to empower people to stand up to these bullies, because that's exactly what they are. They're bullies. Bullies have to use force to get their way. Real adults, mature adults, use persuasion. So let's get back. He's got a lot of problems here we're trying to help him with. We got Carrie in Albuquerque. And so would you contact me off air? We'll get you the documents, and I'll give you the instructions instructions on how to get the habeas corpus done. Now, remember, you're filing a petition for a writ of habeas corpus. Some people think that they just file their own writ of habeas corpus, and so that's not how it works. You petition the court for a writ of habeas corpus, and if you have sufficient, and from a technical standpoint, if you lay out a proper petition and the sheriff cannot show evidence to validate their claim against your daughter, then the court is obligated to order her release. So that's the way it's supposed to go. In fact, it was considered so serious not to move on a habeas corpus that in Arizona, it used to be an automatic forfeiture of the judge's bond when they used to have bonds. But, of course, they don't anymore. They self-insure. Right. They self-insure now, which is maybe something we could talk about later. So what I would recommend doing is getting into the No Stay. I know you're a trucker, but if you have a phone, you can use Skype on a phone. But definitely get into the No Stay Project Skype chat so that you can work on your communication skills and being able to question these people effectively.
One other thing I would like to add is when they incarcerated my daughter, they took her children from her. They're tied up in human services, and she no longer has possession of her children. And, that's a whole other issue that, I guess whenever it rains, it pours with these folks.
Yeah, that's pretty bad.
They come after me like you've never, ever seen. It's unbelievable. Like I was telling you a week ago, they came after me for a case that was 4 to 5 years old, never mind the 180 days.
Yeah, they're criminals. They're crooks. These are not aberrations. This is just the way they do business. When they see any opportunity that they can exploit to exercise control and get some money, they'll do it. So we got to move on. I do appreciate the call, and I know we're having an audio problem. But you contact me off air, and we'll get you set up.
Thank you, sir.
Thank you, Carrie. Again, if you make an order at marcstevens.net, you don't get it, within an hour or so. I'm pretty good with that, except for Sunday. I don't work Sundays, and I can't even look at that stuff. I need 1 day away from all these tyrants to contact me right away. Some people are really patient, and so they'll contact me 2 weeks later. I'm like, hey, I didn't get what I ordered. I'm like, holy crap. And again, sometimes it does, because when you do order the template, you're getting the template for the motion, you're getting the discovery request, the motion in limine, and you're getting the proposed plea. So because there are attachments, yes, sometimes it does go to a spam folder. So always look in your spam folder. If you don't have it, contact me, markstevens@mail.com, and we will get you squared away. And we're going to bring, we have area code 682. Is this Bo?
Yes.
Wow. Well, Bo, where are you calling from?
From Texas.
Another Texan. Well, welcome to the show. What do you got for us today?
Thank you for having me on your show. I'm going to court on December 6th. I have your motions. I don't really know what to do.
Yeah, it doesn't sound like you were really very familiar. So you're not familiar with the show? You haven't been listening very long?
This is my first show.
Oh, wow. Okay. Not a problem. Well, the problem. Well, there's a lot we can discuss before we even get started. Are you in the No State Project Skype chat?
Yes.
Okay. Good. Because usually right after the show, the guys will do a role playing session. So definitely do that because you only have a few days here before doing this. So definitely do that. What we're doing here is basic logic, okay? Fundamental logic. There's no mystery here. None of us here are really reinventing the wheel. The only distinction is the fact that we refuse to take any sacred cows, such as what lawyers will do, and people who are very accepting of authoritarians, is they accept that the foundation of the accuser's claim is a sacred cow that they're just supposed to accept. You're just supposed to accept that if you're in Texas, the laws apply. We don't do that. We take a hardcore skeptic line on that and say, no, there is no argument that is immune from challenge. And so we are taking the Socratic method of just asking questions and applying it to the foundation of the prosecution's case. Because what started all this, because it's traffic, right?
Yes.
Okay, so what started this was a police officer made a legal determination that because you were physically in Texas, the laws he enforces apply and give him jurisdiction to do a traffic stop, right? That's not, right? I mean, you can even ask him that on cross-examination, and he'll admit to that because that's what he's doing. And we are going to challenge that. Does he have any actual evidence? So that's what we have in the motion to dismiss, which you have, is based on the record before you, which is just the traffic ticket. The police officer's ticket has nothing he has said, nothing he has written is evidence to support that foundational claim. And because he doesn't have that, he not only didn't have jurisdiction to write the ticket, the court doesn't acquire jurisdiction, and also even if that wasn't the case where you waived personam jurisdiction for some reason, they can't acquire subject matter jurisdiction. Again, this is in the motion. They can't acquire subject matter jurisdiction because they haven't set forth sufficient evidence to present, to set forth a valid cause of action, which is not just an accusation, it's an accusation supported with evidence. And so that's the basis of what we do. And so another part of it is, for those who are new listening like yourself, is the basic tactic is this. We are going to zealously challenge the prosecution's claims. We are not going to give the prosecution's claims any free passes. But we have to use a priority on what we're going to challenge first. And so I believe it's striking the root or hitting the foundation, that we are not going to shy away from challenging their claim that just because I'm in Texas, their laws apply. And we only accept responsive answers. You see, most of what we're doing, Bo, is asking what are called leading questions. And so it's really easy to know if we've gotten a responsive answer or not. So do you know what a leading question is?
Well, I guess I would need to figure out who is making a claim against me. Is that correct?
Well, I'm asking you what a leading question is. So what I'm going to do is we're going to ask that. I'll bring that up on the top after the top of the hour break. So I'll mute you up. So just hold tight. My name is Marc Stevens. You're listening to the No State Project here on the Liberty Radio Network, talking with Bo in Texas, who is very new to the material, which gives us an opportunity to discuss the basics again, to help get him prepped for court on December 6th. So we got a lot to get to, so don't go away. If you're looking for an effective way to defend against bureaucratic attacks, you found the right place. And for evidence of that, I will have a video with 2 more success stories in the next couple of days. And you can go to markstevens.net, go to the success story page, and there are lots of pages with documentary proof, everything from the IRS to drugs. Again, that's, ethical anarchism for Joe in Hawaii. It was one of those. And also tax situations. So markstevens.net, check that out. I want to bring back on the show, he's new to the material. He's got a court date coming up in Texas on December 6th. And we're going through the Socratic method and how to effectively defend oneself against these attacks. So welcome back to the show, Bo.
Thank you.
Have you ever defended against a ticket in court before?
I have not.
And this is just traffic. This is not a drug case or something really serious like that, right?
No, this is traffic.
Okay, good. So you're not cutting your teeth on a on a DUI or a drug possession charge. So good. Have you done any role playing yet?
I have.
How's that going?
It's going really good. A lot of people on the No State Project, the No Province Project, some side chat. Everybody's been really helpful as far as just willingness to help me.
Okay, great. Well, I'm glad to hear that. And so just like for you, if anyone out there listening wants to hone their skills or learn the skills, go. Yeah, you can do that at markstevens.net. You can get the link for that under upcoming events, or you can contact me at Frank Rizzo 3, and we could put you in there. So that's good, because you need to do that, because one of the constants we have on the show, when somebody doesn't do very well in court, it's usually because they did not do role-playing. So I'm glad for that. So let's just focus on some of the problem areas that you may be having. What are your concerns, or what do you think is your weak point that we need to focus on?
To answer the first part of your question, one of my concerns is I don't know what to do if they don't respond to my motion by the time I show up to court.
Okay, we'll tackle that one. Oh, wait, you know what? All right, well, let's get to that in just a second, because I had asked you if you knew what a leading question was, so I want to bring that back. So we'll get to what do we do if they don't respond to the motion in just a moment. See, I wrote the damn thing down, and I didn't. Okay, so do you know what a leading question is?
I'm not sure. Can you inform me?
Of course. And for those listening, a leading question is a very effective way to question somebody. It's typically only allowed on a cross-examination. So I like to treat all of my conversations with bureaucrats or somebody who's making a claim, I like to treat it as a cross-examination. And the most effective way to question them is by using leading questions. A leading question suggests the answer. A non-leading question is basically open-ended and leaves it up to the witness to supply the information. So a non-leading question is, after you left your house, what did you do? And so there's no information given in the question to help the witness. It doesn't lead him anywhere. A leading question would be, after you left your house, did you go to the victim's home? See how it suggests the answer?
Yes.
That's a leading question. And so, and it's effective because we're controlling the narrative, if you will, and what the witness can respond to. And it's easy for you, as a newbie to this, someone who's new to it, because you know there's only one of two ways it can be responsive, and that's to answer yes or no. It's not open-ended. It's either yes or no, or they're not being responsive, and then you can object and have them be responsive. An example of that is where, let's say you go in, and this is where I don't know how to what to do if they don't respond to my motion. And more than likely what's going to happen is you can get there and the judge just deny it outright. And so a common mistake for people to do is to say objection on what grounds? And that doesn't suggest the answer, does it?
No.
So right. So it's a non-leading question, and it leaves the door. It opens the door for the judge to say whatever he wants and be responsive to your question. So we want to ask a leading question and suggest the answer to him. So a better way to do it is say, objection, you're satisfied that the prosecution has submitted sufficient evidence to meet their prima facie burden on jurisdiction, that there's evidence proving the Constitution applies to me just because I'm physically in Texas. The difference there is you're giving him something to respond to, and he's either going to say yes or no. But you can probably see why it's an effective question, because however he goes, you're getting him more specific about why he denied the motion. Now, if he says no, then why did he deny the motion? Well, if you're not satisfied they met that burden of proof, why did you grant the motion? Is it because you're relieving him of his burden? Are you saying he doesn't have to prove that? So again, you suggest the answer. A lot more effective than if you give the judge an opportunity to give you a narrative. So you see the difference between a leading question and a non-leading question, and why the leading question is so much more effective?
Most definitely.
Good.
The second part of your question, I think my ego would be what I need help with the most.
You think your ego? Is that what you said?
Or just how I come off, like my temperament, how I say something.
Oh, okay. All right. Well, didn't actually... all right, we'll get to your temperament, and because that's really what helps with the role-playing. I didn't really fully elaborate on what to do if they don't respond to the motion. You have an idea, but I want to address that and make sure that we flesh this out.
Got you.
When you first get there for trial, then one of the first things you have to do is object to proceeding because they have not responded to the motion yet. So the prosecutor hasn't responded and the judge hasn't denied it, right?
Right.
Okay. Did you also file and send the prosecutor the discovery request?
Yes.
And how long ago was that?
I did it on maybe a week and a half ago, I think. There
you go. Okay. A week ago, really, even 2 weeks ago is not, so they usually have at least 2 weeks to be able to respond to a motion and a discovery request. So you just haven't gone through the time required. So when you get there, what I would suggest doing is objecting right off the bat that you have a pending motion and a discovery issue that needs to be discussed and settled.
Okay.
Okay, so we got motion and disclosure. We're going over the tactics, what we need to do to effectively defend ourselves against these people. So, not responding to the motion here in your situation, you would absolutely object, and you want to know what evidence the prosecution has, if any, to overcome the motion, since the motion is based primarily on a lack of evidence. See, when you're in there, you're always keeping the focus on the prosecution's burden of proof, not the judge, because the judge nor you have a burden. It's always focused on the prosecutor. And the prosecution may not say anything, but you're still having to go through the judge in your communication to look, does the prosecution have it, yes or no? Okay? So what I'm saying is that you're always keeping a focus on the prosecutor. So it's either yes or no, does the prosecution have the evidence, yes or no? And so what if the judge says something to you that the prosecution does not have to prove that?
I would move to dismiss the case due to the prosecutors or not being able to state a case.
Well, the judge isn't agreeing with you. He's saying that he's given the prosecutor a free pass, saying he doesn't have to prove the foundation of his case. He doesn't have to prove that claim. So asking for a dismissal at that point, he's just going to tell you denied, and we're going to trial. So you need a better objection than that.
How would I object to that?
Well, this is supposed to be a fair trial. Would it be fair to allow the prosecution to argue against you without evidence? So a question that I have for them, and this is a very common one and we talk about on the show all the time, is that objection, you're allowing the prosecution to argue against me without evidence. Are you going to extend me that same courtesy? See, this is a point that critics don't want to address. They just want to turn around and deny that I've had any success whatsoever, and they don't, and they want to make these claims, and they want to excuse the prosecutor, and they'll never address this particular issue not that I've seen. Is the judge going to allow us to argue, or make a claim against the prosecution with no evidence? And the thing is, the reason why he won't allow that is why the prosecutor is not permitted to. I mean, you're bringing out that you're in a rigged game. This guy is so biased against you. And I'm not saying it's a personal bias, that he just doesn't like you as a person. He's just so biased in favor of the prosecutor that the prosecutor can engage in misconduct and argue against you. In fact, the foundation of his entire claim. And that he doesn't have to prove it. That's just not fair. Even if he just said it was prima facie true, they're not going to give you an opportunity to challenge it. And that just shows you that he's holding the prosecutor's unsupported claim as irrefutably true. Because you're never going to hear this garbage in court. Now you're arguing philosophy. Sorry. You're never going to hear that in court. And it's not because they just don't want to say it, that they're just, it's a conspiracy of silence. They're just not going to tell you that, Marc, you're a friggin' idiot and you're arguing philosophy, but they don't want to hurt. They're in a conspiracy that no judge in Canada, Australia, none of them will actually say why you're wrong. They just won't say the P word. That's not what's happening because they're not making that. That is just a stupid internet lawyer claim. So they're not going to say anything like that. We have to address, with an objection, the judge's refusal to hold the prosecution to their burden of proof. And the best way that I know of is to put you in that position, say, will you extend me that courtesy? Can I make a claim against them without any evidence? And you'll accept it. And so, call it turnabout or flipping the context. It amounts to the same thing. And it's something that I did a long time ago when a judge allowed a prosecutor or an attorney to argue and claim he was representing a client. And the judge wouldn't allow a challenge, which is right there by the book. It's a standard 9A challenge. It's a standard challenge. And the judge wouldn't allow it. He says, no challenges to an appearance in my court. So I called somebody up out of the audience and said they were going to represent me in my appeal. And the judge lost his mind. He said, absolutely not. I said, wait a minute. You just said there was no challenges to an appearance. It doesn't matter if he's an attorney or not. You can't challenge him. But they did it anyway. So that was kind of an off-the-cuff thing that I did 15 years ago or more. And I realized, wow, this is pretty powerful. All you do is take what they're doing and you try to do it and see what happens. Because the rules do matter to them when they're trying to convict you. But if it has to do with you or me, showing that the prosecution doesn't have a leg to stand on, if it damages the prosecution's case, the judge won't allow it. Why? Because he is one of the prosecutors. And that's what the evidence tells me.
I just found that motion I'll file and the stamp on it says November 9th.
Okay, so it has been plenty of time. You have, we'll have to address this November 9th. Wow. Let me make a notation of that, and we will finish up in the next segment regarding that. My name is Marc Stevens. Listen to the No State Project here on December 2nd, 2017 on the Liberty Radio Network. We'll be back with many, many calls and a lot more information in just a moment. Don't go away. I want to address something Shelby was saying here really quick, because it does go directly to what we're talking about with Bo. The question he's got here is, what is the point of the role-playing? And the whole point, which I discussed, and there's a video about this, it's stickied on the forum. I've discussed this so many times. And anybody who was in the chat when Tom from Detroit was there knows exactly what the hell the role-playing and all this is about. I wrote about this in Adventures in Legal Land, which was a whole lifetime ago. 14 years I've been saying what the purpose of this is. It is damage control. It is to limit the amount of damage these people are trying to do. The only exception to that really is when someone is doing it strictly as a activist, like I've done, where it's to prove a certain point. Most people just want to limit or negate the damage that these people want to do, and that's the point, to effectively defend ourselves, to limit the amount of damage these predators are trying to do, and they are trying to damage you. There is absolutely no argument there. They want to hurt you in some way. We want to limit that. If we can eliminate it, great. I have absolutely never said on the show that the single goal is to get a dismissal with prejudice. We want a dismissal. If we get it with prejudice, great. We're not always going to get that. No one has a 100% successful or even a 70% record of nothing but dismissals with prejudice. It's a rare thing. We're trying to limit the damage that they're trying to do. That is the purpose. And there is a long history of me saying that. Limit the damage. So I want to get back, because that's what we're doing with Bo. We want to be able to limit or eliminate the damage that these predators want to do. And I don't think that anyone has really complained that they didn't get a dismissal with prejudice, because most of the time, Bo, we're dealing with things like what you're dealing with, where the chances that they're going to refile against you after a dismissal are very, very rare. So hopefully that point. Well, there are new people, so maybe someone like yourself doesn't realize that. We're trying to limit or eliminate, if possible, the damage that they're trying to cause, because we know we're 100% certain they want to hurt us. So,
I would definitely agree with that.
Yeah. So getting back, thank you. So getting back to you filed it on the 9th. That is sufficient time that has gone by so that it is now appropriate to file 2 more motions. And that would be the motion in limine and the motion to dismiss for prosecutorial misconduct. Now, I know you don't have the misconduct one, but you can email me after the show, and I'm happy to send that to you.
You brought me on your show today, and I just want to tell you that I appreciate that. But what I really need to know is you brought here in front of everyone. You've been charged with failure to display your license plate properly. How do you plead, sir? Guilty, not guilty, no contest.
Well, in that situation, so you're okay. When they want you to plea, if they've already run over you as far as the motion and denied it, and you've made your objections and they're not going to budge, you say, and I have a whole video of this. It's in there's an article that's linked to the instruction email that I sent you, and it has to do with the plea of guilty. It stays unsigned unless for some reason the prosecutor throws you a smoking deal that you've limited the damage, or you've done your damage control, and you can sign it. But generally we leave it unsigned. And so when they say, well, I intend on pleading guilty, has the prosecution submitted sufficient facts to prove that just because I'm physically in Texas, your Constitution and code apply to me?
Okay.
Yeah. Now,
would you be open to doing a role play based on what you know about my situation?
I don't know much about your situation other than it's traffic.
Oh, it's a failure to display my license plate properly.
Well, we're doing kind of a role play here.
Okay.
Because generally what would happen, if you're asking the judge if there's sufficient evidence, the judge may just turn around and say, well, sir, if you don't plea, I'm just going to plea not guilty for you and set this for trial.
Well, I don't want to I have no intentions of going to trial. I plan on pleading guilty today.
Well, what you want to say is objection first. So you want to get in the habit of always saying objection.
Objection. Got it.
And the objection that I would make here is, knowing a little bit about their system, there's 2 situations that the judge needs in order to justify pleading not guilty for you, and that is if you are refusing to plea or he can't determine what your plea is. So you ask him a leading question. You say, objection, are you under the impression I'm refusing to plea? Okay? Now it's up to the judge. So that's the objection that I would make with the leading question, because it's very effective, because you're bringing out, he only has one other option left. So if he says, no, he may say, what if he says, well, sir, yes, you are refusing to plea. And if you don't plea, I'm going to plead not guilty for you. You're going to have to answer faster than that.
I thought you were just, I didn't know the question was directed at me.
Well, yeah, you want to do a little bit of role playing, and so we've got a little more time left, and you know, we could do that. So I'm the judge snapping at you, and I'm saying you are refusing to plea, and if you don't plead guilty, not guilty, or no contest right now, I will enter a plea of not guilty for you.
Judge Stevens, I have all intentions on pleading guilty. I have an unsigned guilty plea with me. The only thing I'm missing is the evidence that just because I'm physically in Texas, that the codes are applicable to me.
Well, you want to say objection.
Objection.
You say, and a better objection would be, objection, I'm standing here intending to plead guilty. Why are you insisting why are you insisting that I'm refusing when I'm trying to plead guilty?
Oh, that's a good one, too.
You know, here they usually say, no, you don't want to plead guilty, sir. You just want to play games with this court, and I'm not going to allow you to do that. That's a good response, because it is laughable, but we're limited on time here, so I need you to... How would you respond to that when he accuses you of that?
I'm not playing any games, Judge. I'm just trying to mitigate the threat of violence. I don't even want to be here today, to be honest.
Objection?
Objection. I don't even want to be here today in the first place, Judge.
He doesn't care about that. Stick to the prosecution's burden. Almost the entire focus is always on the prosecutor's burden. Objection. You know that. You have to know that that's not true, sir, because all I'm doing is asking if the prosecution has met their prima facie burden. Doesn't the prosecution have a prima facie burden? Yes or no? And now you've really nailed him, because he knows full well the prosecution has a prima facie burden. He knows that any plea that's entered has to be voluntary and intelligent. And asking if the prosecution has met their prima facie burden is relevant to a knowing and voluntary intelligent plea. There's no reason for you to plea if he hasn't met his prima facie burden. Zero. Hey, we're up against the break, and so I'm going to have to, we've got a whole line of cars. It's not like last week. We got a whole boat of calls, so I'm going to have to let you go, Bo, but get into stay in the No State Project chat and email me for the motion to dismiss for prosecutorial misconduct. We've got 5 more segments, so we'll do what we can to get to everybody. We've got somebody here who, from very close to me. Is this Jenny?
Hi, Daddy.
Hi, sweetheart. You've been persistent. Did you want to make fun of me today?
Well, I heard that the No State Project was doing a raffle today.
Well, you have to be here when you know, for when the prize is awarded or picked.
That's true.
Okay, well, ha ha ha. No one's going to understand what that means, so.
Also, Daddy, I want more money.
You have certainly called the wrong line, young lady. That is funny. That is hilarious, but I do have a lot of calls to get to, so I do have to tell you that good luck with that one, because people are usually they know better than to come to me for money. I'm not that guy. I'm not the one who does a populist show who jumped on a Trump train and made millions of dollars in Bitcoin. So, wrong show for that.
Okay. Well, we're almost home, so see you in a few minutes, Daddy.
Okay, thanks, sweetheart. Yes, one of my children. Hopefully will be with us for and Libertopia.org. She's been there, I think, every year so far. So we are doing it again for May 3rd to May 6th, 2018. Humphreys by the Bay. Wonderful venue. So check it out. Libertopia.org and get your tickets there today, tough guy. And we'll see you there. And maybe we'll have our blues jam. So we have another new caller. We have area code 719. You're live on the No State Project. What's your name? Where are you calling from?
This is Lauren.
I'm sorry.
I'm calling from Longmont, Colorado.
Colorado. I'm sorry. What was your name again?
Lauren, Loren.
Oh, welcome to the show. What do you got for us today?
I sent you an email. I just recently got indicted by the IRS for conspiracy to defraud the U.S. government and impeding the IRS process. Those are the two charges. I've been arraigned, which was very interesting. Spent a couple of days in the federal prison in Denver. I'm out on a cognizant bond right now, personal cognizance bond. And I have a hearing Monday in Sioux Falls, South Dakota, in the federal district court there. So that's basically what I want to talk to you about. I'm a friend of Randy Gross. I think you might have, he's been on your show some. Are you familiar with Randy?
The only thing that's ringing a bell for Colorado was Randy that did a radio show years ago.
Yeah. Oh, yeah. Yeah. Well, Randy that did the radio show, I can't think of his last name, and I sponsored you on a 2-day seminar in Colorado Springs. Remember that?
I do. That's why I remember that Randy. He's never been on this show, but I did his show a number of times.
Yeah. Well, no, this is a different Randy that I'm talking about.
Oh.
And I was actually sponsored the seminar that you put on, 2-day seminar there in Colorado Springs. Randy helped me promote it, and so we were kind of together on that.
Okay, it's coming back now.
Randy Garris was indicted also. He had, in fact, 2 days ago, Thursday, he had sent me some audios of yours, and I got to go through one of them. And then I thought, well, I'll try to get on your show today and just talk to you a little bit about this indictment and my situation, if that's at all possible.
Well, yeah, there's a lot to get to in this one. Wow. What do they? So, as far as the conspiracy to defraud and impeding, what do they? What specifically are they accusing you of?
Okay, let me give you the story briefly. This all started in 2004 with a gentleman his name was John Sheridan, and he got with a father and son farmer near Mitchell, South Dakota. And he started doing trusts for them. He actually became a manager for them. He did everything financially. They just turned over everything financially to him. And he was doing trusts. He started off with one trust, and then he decided to break the land up because these people had a lot of debt. They even had some government debt. And so he broke up the land into about 12 different trusts, because he told me later he wanted to sell the land in parcels with each trust. I told him that was very stupid to do, because you can do that with one trust. What I didn't know is that he put my name in those trusts as a successor trustee. So that's how I first got in. Well, that's what the indictment is first talking about. This, in about 2009, he came to me, wanted me to help him. He wanted to close all those trusts so that there was all the land into one trust, which is what he should have done in the first place. And he wanted me to help me. He wanted me to be a trustee to actually, he would be the settler, and he would put the properties from these trusts into that trust. And then he said, as soon as he got that done, then I'd resign as trustee, and he would take over as trustee, which is what happened. So my only involvement in any of this was at that time, and that was just temporary. In 2011, John Sheridan died. Randy Garris and John were very close friends. John got Randy to be a trustee. Randy signed to be a trustee of the trust that owned the land, plus a trust that did the managing that he had set up of the business, the actual farming business. Randy became the trustee, and he came to me and wanted me to be a co-trustee. I knew the farmers. I knew the father and son real well. And so he wanted me to be a co-trustee with him. And unfortunately, I just told him I would do that. So I became a co-trustee. And at that time, neither Randy or I knew that there was serious IRS problems. We went up there to South Dakota and learned John had created several serious problems. What we did, we tried to, between 2011, 2014, or 13 about, we tried to clean this thing up quite a bit. We did continue doing what John did with those two trusts. And in 13, the father and son got indicted, and there was for evading taxes, there was about 10, 12 charges in their indictment. And I think it was about 2015, this thing carried on for about a year or two.
And, real quick, let's just jump ahead. I think we've got a lot. We can't get into all the underlying details, which sucks because we don't have the time.
Right. Okay.
But
I just wanted to give you a little background.
Right. But so in about 15 seconds. Well, no, we don't have the time. So have you talk about what the impeding, what the specifics of that are supposed to be. So just hold on a second. And this is a mess. You've got a serious situation going on here, and there's some background noise there. But
definitely do have a serious situation.
Yeah, this is very serious, and I have to preface this with, and I've always said this, we've had very limited success at the federal level, especially when it's a tax thing like this, because they just run over people. So you could do everything right. You can show that the witnesses are lying through their teeth. You can have the witnesses actually testify on your behalf, and you can still be convicted. Okay, we had with James, it was bad. The judge even went in and spoke to the jury after they were charged. Okay, so I'm just trying to, what you already know, I'm preaching to the choir. You're knowing this is bad. So when they are accusing you of impeding the IRS, okay, what specific acts are they saying fall under impeding?
They're saying because John moved these properties and the business actually started out with a corporation. He moved it. There was another trust were involved. It was moved in and out of trusts. They're saying by doing that, he was trying to evade paying taxes. And the father and son, they went through the trial. They were convicted. So I know I was there, so I know what you're saying about that. Father got 5 years. The son got 9 months. And Randy and I actually worked and helped with the son. I think that was because he only got 9 months. But anyway, what they're saying is that because John moved the properties in and out of about four times in and out of trust, that he was trying to evade or avoid paying taxes. And that's what they were indicted for, and that's what they got convicted for, too.
At any point, did the prosecution present evidence to show that there was a tax due? And I mean evidence, facts, not legal conclusions.
Yeah, this was back in 15, and as I recall, there was nothing like that at that time.
Well, there couldn't be. They couldn't even attempt to do that.
Yeah, I would agree.
That is a sacred cow. That is a pass that the prosecution gets. They don't have to prove that.
In my indictment, they're not really talking about taxes owed or anything. What they're talking about is the trusts, and the conspiracy was to move them in and out of these trusts. They're claiming my involvement was as a successor trustee, and quite honestly, I was not aware that he was even doing this stuff. I knew he had these trusts at one time when we switched it into one, but I admonished him for doing that. But so what they're doing, they're basically saying that the conspiracy and the impeding was because of him moving these properties into business in and out of, like 4 different times, in and out of trusts 4 different times.
Well, it still boils down to they're saying that their code applies to you and you violated it in some way.
Yeah, that's what they're saying. Correct.
So, okay, so if obviously the prosecution has to have witnesses with personal knowledge of what they're testifying to. And if the witnesses are testifying that you violated the code, well, they have that personal knowledge and that the code applies. Obviously, they're going to try to give them a free pass on that, but that's the way I attack it. Did you file a motion to quash the indictment?
I just had the arraignment last Friday.
Okay.
And so I haven't done anything. No, I haven't done any motions. I haven't done anything. I decided to wait till this hearing is. I understand the main reason for the hearing is whether I plead guilty or not guilty.
Well, the arraignment is a lot more. It is actually more than that. They try to say that that's limited to that. I don't think so. I don't believe their rules actually bear that out because the plea has to be knowing, voluntary, and intelligent. You have to know. You have to know what you're doing, and you have the option, and it should have been done, depending on how long from the time that you were arrested, or indicted rather, that where you were arrested.
This indictment is July 7th. I knew nothing about this. IRS never corresponded with me. They never talked to me. It'd be a week ago last Tuesday. I was in King Supers. I had 2 federal marshals, U.S. marshals, come in behind me. Before I knew it, I was at the counter checking out. Before I knew it, I was handcuffed. And they just had a little slip paper there showing the 2 charges. You've been charged with this. I didn't see the indictment until after the arraignment, which was the next day.
Okay, so you didn't have an opportunity.
No, I didn't have an
to
opportunity
file a motion to quash. I would
even know the background, what it was at all about. This thing came completely out of the clear blue.
Okay, so this is what I would do. I would get a motion to quash the indictment or a motion to dismiss the indictment as soon as possible, and bring up that there's a lack of evidence, obviously, in the indictment. They're just assuming that the code applies, and this is a situation where, again, I know that statists and authoritarians have a really difficult time following this. I know people who make their money off of this system have an extremely difficult time understanding this. But it's so much easier to show with a mala prohibita. This so-called crime only exists by virtue of the statute. So to turn around and say that the applicability of that statute is not an element of the charge, you're saying that the statute itself is not relevant to whether you violated it. It's not relevant to whether you committed a statutory crime, which is absolute madness. Look, that the very definition of mala prohibita, it is only wrong by virtue of the statute. It is absolutely insane. It is asinine. That's actually the more accurate statement. It's asinine to claim that the statute itself is completely irrelevant to whether you committed the act or not, because it's only wrong by virtue of the statute. So, man, I get so tired of the same stupid things that we have to keep repeating here because they keep coming up. I would have that in there, and I do have a template for the feds. And we even know by their own code, Lauren, their own code states that the prosecutor may not put forth a claim that is not based on fact and law. Fact and law. It doesn't say fact, comma, and law. It's fact and law. And we already know by their own standards, the Shaw case that I will have it in this video too. It is prosecutorial misconduct to argue without evidence. End of discussion. If he's making a claim against you and there's no evidence and it's not see, that's the thing. Making a claim against somebody is never a theoretical issue of law. It's always a practical because you're making, with Lauren in Colorado, and I just want to point something out here that's going on in the chat. Maybe we'll have to dedicate a segment on another show to this. If you're talking about public rights and the right of the government to do or not to do something, it is not a red herring to ask a question on ethics and morality, because they lead directly to that, whether they have a right to do something or not. So the moral question is if it's okay and morally justified to force a perfect stranger to give you money. That's a no-brainer. This is exactly getting to why no one in the courtroom for Lauren on Monday will be able to show that there's any jurisdiction. Because forcing a stranger to give you money, I use the word stranger for a reason. That's the context. You have no personal connection to this person other than the fact that you are forcing them to give you money. I'm giving the context in the question. It's very simple, yes or no. Is it morally justified to force a perfect stranger to give you money? And see, that cuts through all this BS. This is the underlying reason. This is the moral imperative here. This is why they have no jurisdiction. This is why they can never have a valid claim, because they are a criminal organization. They are immoral from start to finish. It is not a red herring. I am not trying to deflect attention away. Somebody not answering that is doing something like that. It is the single most important moral question here when we're discussing these things. It's what undoes all of the public relations, all of it, because it doesn't become more moral or it doesn't become less immoral because you are forcing hundreds or thousands or even tens of thousands of strangers to give you money. It doesn't make it morally justified because there's more people being forced to pay you. And it negates this nonsense that this prosecutor will say that he's acting on behalf of the United States, the people, because every single one of us is forced to pay them. They are not representatives. No, they are no more representatives of the community than Al Capone was. So if you're going to accuse me of a red herring, get it right. That's not a red herring. And if you're going to have a discussion on morals and ethics and what's right and wrong, it is not a red herring to ask if forcing a stranger to give you money is moral or not. So anyway, but Lauren, I had to get that out because I don't mind a lively discussion, but when someone accuses me of having a pattern of using red herrings, anyways, but getting back to this, I think that shows the underlying reasons and facts why this prosecutor on Monday will not be able to show any evidence of jurisdiction. But
at the arraignment, the judge here in Colorado, he was really admonishing the IRS. I have a hearing problem. I'm 82 years old now, and I have a hearing problem. And I couldn't hear the judge, but I was watching the IRS person, and she was really had her head down. The judge was really, but I did hear him. The judge then looked at me, and he pretty well indicated that I had even maybe a lawsuit, but he says, Mr. Brown, you have constitutional rights here. And I kind of set me back a little bit because it was interesting. The judge was almost giving me some legal advice, maybe,
What was the prosecutor saying that led him to say something like that, or to admonish him several times?
Well, I think it had. I was not able to hear much that went on.
Oh, okay.
But the IRS said I was a party to this conspiracy, and that then I got into that they said I was a risk to flight, to leave the country. I had recently been to South America, so they were basically defending the indictment a little bit. I don't think they didn't get into it, of course, because the indictment's like 13 pages. But anyway, then the judge said that, and when you said public rights, constitutional rights, I was thinking, it surprised me that the judge was even talking to me about that. And I should have tried to participate more, but they had the public defender.
Oh, no.
And she was doing everything, and I was just I was really out of the picture.
Yeah.
It was all between the public defender and the judge.
I'm sorry to hear that, because they're not going to make the defense and make the challenges that you're going to need to affect. And I want to welcome to the broadcast today the fact that we do have other listeners who have probably been taping, recording and eavesdropping in on all of your conversations. So another reason why I did the little rant that I did before about the moral issue.
Yeah.
But none of the issues
I wish I had had a way of recording this. I don't.
Well, it is being recorded. I mean, it's recorded for the podcast, and it's recorded. The network and has a recording, so it's definitely being recorded. So you can listen back to that. But there's not much we can do as far as a challenge because the public defender is not going to help you out that way. Again, you could ask them, well, look, shouldn't you be zealously challenging the prosecutor's arguments? And they'll say, well, yes, of course, that's my job. I have to do. Yeah. Should you give the prosecution any free passes on their claims against me? Well, no, of course not. That would be stupid. No good lawyer would do that. Great. So you're willing to challenge the prosecution's main claim that just because I'm physically in the U.S. that the Constitution and laws apply to me. You're willing to challenge that, right? And then they'll say, well, so you were lying when you said that the prosecution shouldn't be given a free pass. Got it. So, you just lied to me. So it's really unfortunate. I mean, I would still say if they can be standby, like what happened with James up in Alaska, so that you can, they can help you with objections and whatnot. Not that they helped James at all. They let them call him a tax cheat, and they just sat there on their phones, those stupid, slimy sleep.
Yeah. In my whole indictment, they're not trying to get any tax dollars from me at all. Here's the bottom line, Mark, and this is the IRS, the one trust, the land trust that Randy and I are trustees of, there's probably as much as $3 million there. The IRS to the father and son, they were convicted, and the IRS is wanting something like $1.8 million from them. I really believe what this is all about is that the IRS is wanting that land.
They probably do. Look, we're up against a break, and I'm sorry I got to let you go because we got a lot of calls. But listen to the show, listen to the other shows, and get into the No State Project Skype chat so you may be able to do something to defend yourself on Monday. But definitely let me know how it goes. I appreciate the call. My name is Marc Stevens. This No State Project for December 2nd, 2017. We'll be back in just a moment. Hopefully, Lauren's still listening and knows that wish him luck, and he gets into the No State Project Skype chat and gets some role playing and try to help. Because the public defender is not going to do that. Yeah, look, they're not going to challenge the foundation. The prosecutor's case, we know they're going to give him a free pass. We know that. And they're probably not going to want to file for discovery, in the Brady material to see if they have any witnesses with personal knowledge of the matters they're testifying to, because once again, they're going to give them a free pass. That's what they do. Anyway, I mentioned him earlier on the show. I believe it's him. But we have Eric in California.
Hey, Mark.
Yes, is this Eric?
It is.
Welcome to the show. You got some good news, right?
I do. So I was in court Friday, filed your motion of limine, challenging the original restraining order. She didn't show up. The judge asked me, had I seen her that morning? I said no. Without hesitation, goes, I'm dismissing this. This is not just a restraining order, but they like to call them protective orders.
Right.
And they take them pretty serious out here. It was a 1 year. It was extended for 5 more years after that a year ago. Without hesitation, this judge just dismissed it for my ex and our child. So we're talking craziness. So it gets a little bit better. I talked to the public defender for the other case for violating this. Told him what had happened. He said he's never heard of such an incident happening where a restraining order that's active has been dismissed. First time he's ever heard of that. He said it's only typically when it expires or if the plaintiff withdraws it. He did say that be prepared that the the prosecution's probably still going to try to prosecute you for violating it. I took copies of them over to Concord Court, filed one with the clerk there, gave a copy to Tiffany. She was delighted to see me, so much so she had a bailiff come over to escort her from her office to the courtroom because I was sitting outside the DA's office hoping to speak with her.
This is Tiffany Castillo?
Yeah, Tiffany Castillo. Miss Sunshine.
Oh, maybe she's going to look to get a protective order against you.
You would think so. She needed a gentleman with a gun to escort her from her office to the courtroom, which couldn't have been more than 50 feet. I'm sitting outside her courtroom with the security guard in the hallway when you check in, the metal detector guy. My family member is with me. And I'm like, are you serious? She goes, we're not going to talk outside of open court based on our previous phone call. And I wanted,
wow.
Like you mean the one where you evaded everything. So,
wow. So,
anyways, I did ask the court clerk to make sure that the plaintiff had been served properly. They said yes, they had. Mailed her a copy of it. I was surprised she didn't show up. Didn't have a lawyer there. Again, if she had the evidence of jurisdiction, either her or an attorney would have shown up to present it, or the judge would have argued it for her. So,
well, first, congrats on that. And you're going in on, you have to go in on Monday to see Tiffany.
So it gets, lovely Tiffany. Friday turned out to be her last day at this court. She was changing. So I will never get to see her again.
Oh, no. So Tiffany, I don't have to prove that. Castillo and Tiffany, the alleged evidence is in the police report. If you can't find it, get an attorney to explain it to you. Castillo.
Well, no, the lady that said that it's in the police report will probably be there tomorrow. I don't have her last name, but her first name is Victoria. I think she's a little younger than Tiffany.
Younger than Tiffany? What is Tiffany, 26?
Yeah, younger.
Holy crap.
Yeah, like 25, 26.
Okay.
She was a deer in the headlights last time I was in court with her. She's the one that said you need to get the attorney to explain it to you.
Okay, I apologize. I
That's okay.
Remembered it as Tiffany, and I've mentioned that on the show a number of times. So there's no need to belabor that, other than to say that you want to object to that and tell them, look, you're impugning my intelligence now. Just cite it. I know, there's a difference between you citing it and me not being able to understand it. I can't possibly even begin to understand something that isn't even apparent. If you would just stop withholding evidence or lying that you have evidence, we could move forward. Hi. I think somebody on the chat called it, instead of saying Massachusetts, it's actually Massachusetts. And so Miss Castillo and this other one certainly. Anyway, okay. So you got to go in on Monday and see these people.
Yeah. So I'm hoping they'll throw it out. I mean, there's no more restraining order. If they do want to try to prosecute me, I'm calling in to ask how I should attack that. My first thought was there was no jurisdiction from the beginning, so it's basically an invalid restraining order from day one that should never have been given out. I don't know if that's going to work or not.
Well, it's certainly but it's a strong position to take, because if you can knock the foundation out of that, it's just like if you can knock out probable cause. If the police didn't have probable cause, the whole thing gets tossed out, unless they can show that they would have discovered the information and the evidence independently. But here, I think it's pretty obvious that if you knock out the foundation, if the restraining order wasn't valid to begin with, you had no obligation to comply with it. So I think it's a very strong position. It was the one we spoke about the other day. I would still be hitting that, hardcore. And now that it's gone, wow, it should be even easier. But they are probably going to argue it doesn't matter. It's gone now, but it was still in effect on this day, and that's why you counter objection. There hasn't been any evidence shown that there was jurisdiction to issue it in the first place.
Yeah, well, now I can hold her feet to the fire even more along those lines because she gave me that witness list. I'm going to ask her if the plaintiff doesn't have the evidence of jurisdiction and the judge didn't he didn't try to argue anything. I'm like, how could your police officers possibly have evidence of jurisdiction?
Well, that's a point that you bring up about prosecutorial misconduct in that this Victoria lied and said it was in the police report. All you have to do is have a cop on the stand and hand him a copy. Say, find it. But before that, you can say, look, it's very simple, very simple. If she can actually cite this alleged evidence in the police report that she said was there, and she's not just lying, I will plead guilty right now and avoid a trial. The ball is in her court right there. She either craps or gets off the pot. I'm it's such I'm out of metaphors at this point, or now, but it's her burden, and if she, obviously you would be objecting. Look, if she doesn't, it has to be dismissed. End of discussion. But I will plead guilty and avoid the trial right now. Right friggin' now. So hold on just a moment. We are at another break, so I apologize. My name is Marc Stevens. You're listening to the No State Project. One of the success stories that we mentioned earlier, Eric in Massachusetts, did one of the very rare thing and got a restraining order thrown out. So we'll finish up with that, and the next segment will be back in just a few moments with the last segment. Wow. Eric from California, who got a restraining order thrown out, which is great. Obviously, if there was evidence, they would have just shown up and given the evidence. Or the judge would have just denied it on grounds that he's already pretty certain that they have the evidence. It's great that they did the right thing because it's not up to the judge to do the plaintiff's job. The plaintiff bears the burden of proof on jurisdiction, even in a civil proceeding where the burden is not beyond a reasonable doubt, but by a preponderance of evidence. But the defendant doesn't share any kind of burden in a civil proceeding on the issue of jurisdiction. That is borne solely by the one who invokes the jurisdiction of the court. It's a basic thing. He who invokes the jurisdiction of the court bears the burden of proving it. It's pretty old, pretty standard. But they like to give, and what Lauren's going to find out on Monday, hardcore, is how they love to give the prosecution a free pass. And Eric, you've been through this already. You already know. Didn't the judge actually back up this Victoria by also doubling down on the lie? Mm-hmm. Yeah, so the lie I'm talking is that the evidence, this alleged evidence proven the code applies in the Constitution, is actually in the police report.
That's what they said, the prosecutor and the judge. The judge said he believed it was in the police report. Wouldn't force her to cite it.
Do you want to say the judge's name on air?
Yeah, you can go after him. He is a piece of work. His Judge Sarason, his first name starts with an E. That's all I remember. He's an older gentleman, maybe like 70-ish with glasses. Okay. And as far as I'm concerned, just corrupt.
Yeah, and when Eric is saying go after, it's a matter of is a journalist, as a radio show host, and exposing the man publicly for what he is, and the idea that somebody. This is what kills me. We have gone into federal, state, and local courts willing to plead guilty if the prosecution can just point out this evidence. Now, this is different than other situations and what the critics talk about. This is not a matter of where the judge is actually saying they don't have to prove their claim. They're not saying that. They're actually lying. Well, it's a different lie. They're lying, saying that they do have evidence to prove it. They have to have the evidence to prove it, but the evidence is in the police report. So where are the critics that would come out and correct Judge Sarason, say, oh, dude, you don't understand. Marc Stevens is an idiot. You don't need to have evidence to prove that. All these internet tough guys, why don't they come out and say, this judge is wrong. He's 70 years old. He's probably been a judge for the better part of 40 years, and he hasn't been able to realize what all the smartest lawyers in the world already know, that jurisdiction's a pure issue of law requiring no evidence? So what do we need to do to make sure that you are effective on Monday?
Well, we went through the script earlier this week, so I just transcribed it all, got my notes, I'm prepared. Just wanted to go over this thing. So I'm going to use the unsigned guilty plea. Let's do it now and go home. Otherwise, you'd mentioned something about saying to the judge that, DA is lying about the police report because there's no way the cops can have it if the plaintiff doesn't have it and the other court judge doesn't have it. He just dismissed it. So they're lying there. And you said to say, I want her sanctioned. I'm going to file a felony complaint against the DA.
Oh, I didn't say file a felony complaint. I just mentioned it is a felony. But you can file the complaint that I mentioned that you file is against against her with the Bar Association and against a claim against Concord, Massachusetts insurance, their risk management.
Okay.
Yeah, there is a radio show host who claims that you can file felony complaint or indict as a private individual, but I've not seen any evidence of that in the United States.
Okay, so can I file a criminal complaint against either Victoria or the DA at this point, since there clearly is no evidence? They lied in court about it.
There's no doubt that you got the goods on them as far as lying. Now, the issue is, who would you file a complaint with against her?
I guess, I don't know, the court? Just file directly there, or do I have to go get a police officer to take the statement?
You could get a police officer to do that, sure. And you think he's going to take the complaint? And now let's say the police officer takes the complaint, okay? Mm-hmm. He has to file it, and it has to be prosecuted by somebody. It's a felony. And the police officer, what I'm getting to is, you're going to be filing it into her office. Do you think they're going to prosecute Tiffany and Victoria? Their own office is going to do that?
Yeah.
No, you're not going. Look, I don't want to sound like some, just knocking down people's ideas. When they have merit, yeah, I'll back it. But here, I don't see it going anywhere. I think you can definitely get a lot further on a complaint or a claim against their insurance than filing a felony complaint again. Let's give it some context here, right? Ken Anderson is the first prosecutor in American history to go to jail for misconduct in office. He got 10 days for putting Michael Morton in prison for 25 years. He's the first one in history. So, given that, I don't think you have any chance whatsoever of... the only thing you would accomplish by doing that is to show that the prosecutor's office is biased in favor of themselves and won't prosecute one of their own. That's what you'll show. But you'll never get him. You'll never get her prosecuted for a felony, or you'll never get her prosecuted. Period.
Okay.
Even if you had a gung-ho cop that realized how corrupt the office was, his complaint wouldn't go anywhere. Because even if he got it filed in court, it would be dismissed immediately. And I don't think you've got any cops with that kind of integrity.
Okay, so what's the best way of going about it then to say she's lying? I want her sanctioned, I want to file a complaint against the Bar Association concerning a claim against the county's risk management insurance.
Well, you would say objection. She has not only engaged in a Brady violation, she has lied, stating in open court that the alleged evidence is in the police report, and she cannot cite it. But I'll give one last opportunity, because I do plan on filing a complaint with the bar and against the county's insurance for what's being done here today. All she has to do is cite it, and I will plead guilty right now. Cite this alleged evidence right now. That's the way I would put it.
So, okay, I got that. I'll do that. If push come to shove in court, if they're like Brady violation, what's that? And they don't care. Should I take this thing to trial to have to appeal it, or can I ask them for a stay right now and say I'm going to file a writ of mandamus and prohibition and see if we can get this whole thing stopped and appealed?
Well, they're not going to stop it for that, but you may ask for a continuance to be able to prepare better. But
I mean, can I do anything with the fact that she lied? The Brady violation. What?
Well, let's address this thing. If they actually say to you, "What's a Brady violation?" You say objection. I want you to say on the record very clearly that you don't understand what a Brady violation is, because I'm very sure the appellate panel would like to hear that two experienced lawyers have no idea what a Brady violation is. And they may say, "Well, we know what it is. We want to know if you know what it is." And he's like, "Excuse me, I'm tired of playing games here. You forced me to be here. A Brady violation it's in my documents. If you don't, a Brady violation is you have failed to disclose exculpatory evidence." Now, can we move forward and see if she...
Should I ask him?
Well, we're actually up against the break.
You get a lawyer to explain that to you.
Yeah, that's good. If you don't know what a Brady violation is, get a lawyer to explain it to you. I appreciate the call. We're completely out of time. My name's Marc, and let me know. Good luck. Well, let me know what happens on Monday, Eric. My name's Marc Stevens. Listening to the No State Project here on LRN.FM. We're live on Wednesday on the YouTube stream. So till then, salud.